Brandy Leigh Frame Taylor, now Tipper, versus Joseph Daniel Taylor.
Oh, you may come forward. Good morning.
I'm Jonathan Turner. I represent the appellant in this case, and I'll reserve 5 minutes for...
5 minutes, certainly.
Thank you. This case arises out of Lincoln County on a trial of a parenting plan and contempt that happened back in November of 23. In that case, the judge found the appellant guilty of 71 counts of contempt, and then on the custody side, he changed custody from the trial judge changed from the mother being the primary parent to the father, and then making the visitation of the mother unsupervised, and then actually supervised, and then pending a mental eval, whether or not she would have that happen. So,
And the mental evaluation happened after the entry of the final judgment, and that's not before us.
no, it's not, Judge. That happened later on.
Thank you.
We didn't appeal that. So I'm just going to go over first the criminal contempt, and then I'll go over the parenting plan part. As far as the criminal contempt, we would argue that there are two main issues: that there was one, improper notice, and two, that my client, the appellant, was not willful in any contempt. First, for the notice, if you look at what was notified of the contempt issues, there were 3 in the pleadings that the judge noted. One, it was the appellant didn't encourage visitation with the father. 2, not discussing case with the minor. And 3, not engaging in joint decision-making. So there were 3 counts in the pleading. However, when the judge made a ruling on the contempt, he didn't even address the one discussing case with the minor or engaging in joint decision-making. Instead, he found the appellant guilty of 71 counts of not encouraging visitation with the father.
And that corresponded with each of the missed visits.
Yes, Your Honor. So that's how he obtained that. But when the original notice was given, that was done back in October of 22, so there wasn't even that much time that even elapsed. But more importantly, there was no allegation of 71 contempt violations at any point in time to even give my client notice that she was on notice of being potentially facing 710 days of incarceration.
Well, wasn't it clear that the notice pertained to every week's visitation not occurring? Wasn't that apparent from the notice?
It just said, well, we would argue that it wasn't apparent because they just said that there was not visitation, but when it was listed in the pleading, there was only 3 counts.
Okay, but we ruled out 2 of them, so there's 1 count you want to talk about.
Yeah, so there would be 1.
So let's talk about the visitation count.
So the visitation count just had a period of time on it, but it didn't say like, okay, this visitation didn't happen, this visitation didn't happen. It didn't give notice of any time and place of exactly what was happening. And we would argue she
Time and place of exactly what was happening. Wasn't there a time and place for visitation to occur in the parenting plan?
Yes, Your Honor, yes.
Okay, then how in the world could she not know what was going on?
We would argue that it would be different to know that, listen, you didn't encourage visitation, to know that it was actually that many counts. That it wasn't really explicit at any point in time. And there was nothing even mentioned on the trial day that it was even that many times.
Okay.
And when the pleading happened, that was a year later that it.
So your point is every week they would have had to file an amended petition and an amended notice of criminal contempt?
Or some amended petition saying you're facing this many counts.
Okay.
We would also argue that on the second part that it wasn't willful. So the findings were that there was a drop-off point for the child on these days per the parenting plan. And on the last day that the father had custody, the there was a big, the mother couldn't get the child out of the car. There was a big problem with that. The child, by the way, is 9 or 10 during this period of time.
You say the mother couldn't get the child out
child
of the
was
car.
resisting
Didn't
it.
the mother repeatedly testify that she wasn't going to make the child get out of the car? And no court order would convince her to do so?
I don't recall the court order not saying that, but I do recall a point in time where she did, I agree, that she wasn't going to make the child get out of the car. And that
But-
would be,
But
that's,
I thought she repeatedly testified that there's nothing the court can do to make me force my child to visit his father.
I don't recall that, but I wasn't the
Okay.
trial attorney, Your Honor.
You don't think that's a fair assessment of her testimony?
We would argue that if she took him to the drop-off point,
Yeah.
and the father was there at the drop-off point, and he didn't get out of the car and do anything, and the child wasn't getting out of the car to do anything, that she wasn't willfully trying to disobey a contempt order. Now, granted, the visitation didn't happen, but it wasn't, from the reading of the facts, it's not necessarily willful that she's trying to violate a court order. I mean, if she wasn't showing up at the...
Wasn't the testimony that she and her relatives told the child to not have anything to do with their father? And I can't remember, forgive me for my lapse of memory, but wasn't there testimony that not only the mother counseled the child not to do things, but her immediate relatives did as well?
You're correct, Your Honor. So the
Okay.
parents did that in her presence, and she didn't make any
But
action to
but
say
your
anything.
point is that the mother didn't willfully fail to see that visitation occurred,
That's our point.
Okay.
I mean,
even though she told the child and her relatives told the child not to do it.
well, we would argue that she was taking action by going to the drop-off point.
Sure,
It wasn't
yeah.
like she didn't show up.
Yeah,
If she
she-
didn't show up,
She showed up in a car with the child.
Yes, Your Honor.
That's undisputed.
and the father showed up, or his mother showed up, and they didn't get out of the car or do anything either.
I mean, so it sounds like ultimately the mother here is just allowing the child to make the decision about whether or not visitation would occur or not. I mean, that's my reading of the briefs here. Is that what's happening?
I would disagree with that, because what action is she supposed to take at the drop-off point? Pull the child out of the car, deliver it to the father? The father's not helping, he's not doing anything. Our argument would be that the child's too old to do that. It's too large of a child. And basically, that's the finding here, that if you go to a drop-off point and the child refuses, and basically, it would be like the mother has to take the child out of the car, physically remove the child, and deliver to the father. And we would submit that she wasn't willfully trying to disobeying. She was obviously having parental problems. And I would submit that it wasn't willful.
Well, there was one telling exhibit or exhibits where the child was shown photographs of visiting with the father and his immediate family. And the child's response was to break down in tears, which indicates to me that the child missed the father and his family, which seems to be contrary to your argument. And there, in every parent-child relationship, one of them has to make decisions, and a lot of times parents have to tell children to do what the children don't want to do. But I understand your argument.
Okay, fair enough. I'll just move to the parenting plan real quick. As far as the parenting plan, we would submit that the judge improperly applied the standards that are required. Under 366106, the judge gave no weight to 1 and 5 due to alienation, even though strength of relationship with the mother is important, the fact that she's a primary caregiver. On number 6, he applied the factor that love affection is not applied, but he didn't give any reason other than it wasn't in the best interest of the child. Submit that he's not even weighing that factor. And number 8, the judge said that the appellant needed a mental exam, but he gave no reasoning for that. Number 11, about the child being abused, he applied once again the best interest of the child and didn't really apply that factor, but we would argue that he erred in changing custody because, well, even if you grant that he should have changed custody, the judge didn't apply 36-6301 or 36-6406. So 36-6301, after award of custody, court shall grant visitation as will enable the child and non-custodial parent to maintain parent-child relationship. The judge, despite the guardian ad litem, changed custody, but he went further. He even made it supervised, and then pending a mental evaluation, basically not encouraging any relationship between the mother and child. And we would submit that based on 301 and 406, he didn't apply the proper standards.
Thank you. We'll hear from you further on rebuttal.
Thank you, Judge.
Please come forward. Good morning.
May it please the court. Pardon me, it is not a warm day. It's a cold day, and we have come from Fayetteville. May it please the court, I'm Pat Fraley, with emphasis on my maiden name, Matthews, instead of Fraley. I'm sure you're all familiar with Ray, and he is a wonderful friend of mine, even though we've been divorced about 48 years. We have a son, I think, who's appeared before you all. At any rate, I'm a member of the Lincoln County Bar, and I represent Joseph Taylor in this case. And this is a post-divorce matter, but I'm not really clear on procedure here, and I need some help. I do not pretend to be one who appears before you often, but I caught something at the very end and brought it to your attention. And that was a motion to dismiss that was filed last week. And I learn something new every day, so help me if I've done something wrong. My motion to dismiss was based upon the fact that there is no motion to alter or amend before the trial court. And so on that basis, I have asked that the appeal be dismissed.
All right. Now, it's my understanding that this was not a jury trial, was it?
It was not.
And the motion that you're referring to, the motion for a new trial, is a mandatory motion before an appeal from a jury decision. It's not from a bench trial or a non-jury decision.
So
And your motion didn't cite any authority
yes, sir.
other than saying they didn't file
Yes, sir.
a motion for a new trial. So I'm not aware of any basis to grant that motion, but the panel will discuss it.
Well, thank you so much. I appreciate that. The cases that I read, first of all, it was a 5904, which was not for a new trial, but for a motion to alter or amend. Okay. And it appeared to me that it was mandatory, but I'm learning something new every day.
Okay.
And I'll tell you why it occurred to me that a motion to dismiss might be appropriate. I have two more appeals, which will be coming up before you, not having done one in about 10 years. And the third one is a termination case. And in reading Rule 8, it says at the very bottom that in a termination case, the motion to alter or amend is not required. And when I read that, I went to 5904 and read the exact wording of the motion to alter or amend, and it appeared to me to be mandatory, but obviously you know more than I do.
Well, I could be incorrect, and my colleagues may educate me. So.
Well, you're all three going to educate me, and I appreciate that. In regard to the case, I was present. Mr. Turner was not. And Chancellor Cox did, in fact, take up the issue of contempt. The notice was pled in the original pleadings. We were not the petitioner. We were the respondent.
But you had to
Sir?
But you had to expressly file a petition for contempt.
Yes, sir.
Yeah, and you did that.
Yes, sir.
Okay.
And then it was, I deposed Ms. Tipper and also questioned her, and I believe that that is Exhibit 12, I believe, is her her deposition. I'm not sure, but I can look it up. Pardon?
Would you like to get a glass of water?
I don't want to lose my time.
Well, we can stop the clock.
Well, that's all right. If I have to, I'll let you know. The issue of contempt was brought up in her deposition, and she was questioned if she was aware that she could be held in contempt by the court. She said she understood that. The issue of contempt was again brought up in chambers before the trial, and the statement of evidence has all of this in it, as well as my brief. But the judge said, asked her attorney if she was aware of the fact that criminal contempt had been pled, and he said yes. And then her lawyer voluntarily put her on the stand and questioned her.
And asked her if she wanted to waive the right to remain silent, and she said
she did.
she waived it.
She did. And not only did she do that, but she stipulated to Exhibit 8, which was my client's notes regarding the times that the father had come to get the child, or his mother.
Mr. Smith
Thank
is
you
going to
so
save
much.
the day here.
I appreciate it.
If we need some water, we'll ask you also. So, thank you.
She also stipulated to Exhibit 8, which was his notes regarding the times that either he or his mother had gone to get the child, and the child had refused to go. One thing that I would point out in the statement of issues, or of evidence, is that, and I've forgotten the page number, but it was at the end of Mr. Taylor's testimony, may have been right in the middle. He said that on October the 5th, that was the last time he had his child with him. And he said that his child made a statement to him that he did not understand. And the statement was, "I'm going to be gone for a long time. I won't see you for a long time." The very next day, October the 6th, was when he went to get back the child, and the child got in the floorboard of the car and wouldn't get out. And he said before he got in the floorboard of the car, he giggled. And he thought that was very strange that the child thought this situation was funny. I questioned the putting the child on as a witness, and it came out, as you all are very well aware, and I appreciate your attention to the record. But he said that his grandmother and his stepfather and his mother had told him that if he continued acting this way, that he would not ever have to go back to his father's. And I asked him a question. I said, "Did you think your father would stop coming?" And he said, "Yes." The father never stopped coming. He came, or his mother, every single time. And also in the statement of evidence, I questioned Ms. Tipper and Mr. Taylor. And Mr. Taylor said that she had told him not to lay a hand on that child. She'd also told him that he couldn't take the child to his Protestant church because she said that the permanent parenting plan said that he had to take the child where she told him to take the child. So that's where we are. Now, the chancellor said that this was a classic case of criminal contempt and of parental alienation. We have asked for costs, obviously, for this being a frivolous appeal. We have also asked that we don't think that he gave her enough time, quite frankly. He found her guilty of 71 times. Incidentally, when I questioned her, I asked her, and this was on the second day of trial, I asked her if she had started the visitation back in light of what had happened in the first day of trial. And she said no. She said 8 times, which is in my brief, 8 times that she would not obey the orders of the court. 4 times at the trial and 4 times in her deposition. So he actually sentenced her to 60 days consecutive with only 3 weekends to serve. So that's, if you have any questions.
I'm hearing none. Thank you.
Yes, sir. Anybody else? Thank you so much.
All right, thank you. Rebuttal?
I'm just going to be brief, Your Honor. As far as the notice about the contempt, about the notice of that the judge gave in chambers, the appellant wasn't present, and all he did was say was a Rule 42 notice given. He didn't explain what exactly was the notice, and so it wasn't really explicitly given by the judge to the appellant about exactly what it was, the contempt allegations.
Well, isn't the petition for contempt in the record, and
It is, Your
and
Honor.
it says what it says?
We're not disputing that,
Okay,
Judge.
very good.
Um,
But part of your point is that if they wanted to complain about failed visits after the filing of that petition, that they needed to file an amended petition.
That would be part of it, and part of it was the general number of counts wasn't, the appellant didn't realize what it was.
All right.
And as far as, we would contend that it was not willful contempt, because this would be an easy case if she didn't even show up all those times. But the fact that she was showing up and neither party really did anything, we would submit that really she wasn't willfully trying to disobey. If she was willfully trying to disobey, she wouldn't show up.
What do you say about her statement 8 times in the courtroom that she was not going to obey the order?
Well, I would submit that that was after the fact, that she,
Well, at least some of it was before the fact, because there were 2 trial dates about a month apart. And some of her denials, some of her statements said, "I'm not going to comply." And then she continued to not comply, and then she repeated it again. So that wasn't after the fact, at least some of those were.
well, we would submit that despite that statement, the fact that she showed up, we would argue, what is she supposed to do? Take the child out of the car? Is that the ruling of the trial court? That
What do you say about the counseling from the mother and the grandmother and the stepfather telling the child not to visit his father?
We would submit that the mother wasn't the one doing that, and that was our parents, and that doesn't mean that that's necessarily true, that there was going to be no visitation. The fact that they made that statement but still continue to drive to the location kind of goes against that fact that that she wasn't trying to do anything for the court order.
How did these exchanges work? Did they just drive up to a particular place and the child get out and get in the other car?
That was my understanding.
There's
but
no interaction between the parties at all?
I wasn't there during the trial.
Well, yeah, but you should still know what went on.
I understand, Judge. My understanding was that they would meet there, and then the child would go and be transferred. But after the fact, when the child didn't get out, the father didn't do anything also.
Had there been difficult exchanges before?
The last exchange, there was a difficult exchange where the child was refusing and getting in the floorboard, and that was on tape, I believe. And the mother had trouble getting the child out.
Okay, thank you.
As far as the motion to dismiss, we would submit that should have been filed with the brief, and there's no case law to support that motion.
That issue wasn't raised in the brief.
No, it wasn't raised in the brief, Judge. That should have been raised earlier. That's all
All
we
right.
got.
Thank you.
Judge.
Thank you both. We'll take this matter under advisement.